Okay, welcome. My name is Anna. I am a program coordinator at the Lawyers Committee for Civil Rights, our economic justice program. I'm supporting this webinar in being able to provide a connection to our wonderful attorney that's volunteering today to present, Annalisa Cooper. Go ahead and start when you're ready, Annalisa. Thank you so much for providing this information for us.
Yeah, absolutely. Hi, everyone. My name is Annalisa Cooper. I am an associate at Morrison & Foerster, and I am in their technology transactions group, which means that I deal with a lot of commercial contracts and in particular have a specialized focus with intellectual property. Before joining MoFo, I had a background in IP litigation as well. So if you have any questions during this presentation, feel free to just add it to the chat and throughout the presentation, and we'll have a period at the end as well to address questions, but I'm happy to address them as they come up. And before we can begin, I just wanted to read this disclaimer to you. The verbal and written information contained in this presentation has been prepared by the Lawyers Committee for Civil Rights of the San Francisco Bay Area. It is not intended to constitute legal advice. The Lawyers Committee may have made reasonable efforts to collect, prepare, and provide this information, but do not guarantee the accuracy, completeness, adequacy, or currency of the information contained in this presentation. The publication and distribution of this presentation is not intended to create, and receipt does not constitute, an attorney-client relationship. So with that, we'll get started. As an overview, we'll go over what a contract is, its contents, the types of terms that are contained in it. And then we'll go to contracting tips and negotiation tips, and then finally we'll end with review. So what is a contract? At a very high level, it is a promise or a set of promises that are enforceable in court, and it can be oral or written. In very limited situations, it must be written, but generally speaking, it could be oral or written. And as a general business practice, it is always better to have it in writing. And we'll talk a little bit about why. So why should the contract be in writing? It's easier to prove. So if a contract dispute arises, which we hope that never happens, but if it does, and you have to go to court, if a judge has a contract in front of him or her, it's easier to determine what the parties intended when they agreed to the contract and what terms they were thinking about and what each party's obligations were. If it was an oral contract, then you have to go through the whole, they said this, I said this, and it's harder to prove in court. In terms of the applications that you might find for contracts in business, you can have contracts with clients, customers, vendors. If you're purchasing third-party materials, you should have them with your employees, especially if you're an IP-focused company. It would be very good to have a confidential information and invention assignment agreement, which protects. It basically obligates the employee to protect your confidential information and your trade secrets, and it requires them to give you ownership of all of the intellectual property that they might generate for you during their employment. General offer letters, employment agreements are also contracts that you should require your employees to enter into. Independent contractors or subcontractors, potential partners. This is non-disclosure agreements are a good type of contract to enter into if you're looking to partner with another person and you'll be sharing each other's confidential information, or one party is sharing their confidential information. It's important to make sure that the other party doesn't take that confidential information and just do whatever they want with it. So that's why you enter into a non-disclosure agreement. And it's really important to enter into that as soon as possible before any confidential information is shared. Business entity formation, corporate filings and incorporation documents and operating agreements, all of that should be in a formal contract. And if you're working with capital providers, credit agreements all need to be in a formal contract. Public versus private contracting. So if you are working, or if you're contracting with the government, there may be additional flow through terms, regulations that apply. So just beware if you're working with the government that there may be additional aspects to that relationship. General contract matters. So in short, a contract generally needs 3 broad categories of to be fulfilled to make an enforceable contract. The first is an offer, the second is acceptance of that offer, and the third is consideration. And consideration is a bargain for legal exchange. So you need to be exchanging X for Y. Unilateral actions do not make an enforceable contract. So you can't go to your neighbor's house and clear out their gutters and then demand that they pay you for it. You unilaterally acted, they didn't ask you to. And so generally that's what is required for an enforceable contract, but not all contracts are enforceable, even if they have consideration. Nominal consideration is considered a very small amount, like a penny or something, or $1. And that might not make the contract enforceable. Gifts are also not considered consideration. Yeah, if you say that you're going to give someone a gift, that doesn't make an enforceable contract. And contracts with minors. To enter into a contract, you have to have legal capacity. So if one way to not have legal capacity is if you're a minor. And so if you're entering into a contract with a minor for any reason, make sure that their parent or legal guardian signs for them. When you are dealing with the other side, when you're going to make a contract, don't misrepresent the facts, because it creates all sorts of implications. It might not make the contract enforceable, and it just creates all sorts of problems. So be truthful. In terms of modifying contracts, amending them, you should also have any amendments in writing and in assigned writing. And it's always, avoid ambiguous terms. So ambiguity is very difficult to avoid when you have any written word, but try your best to eliminate all ambiguities. And I find that when drafting contracts, it's always good to just put your your other cap on and say, how could this possibly be interpreted, and think of all the different ways that it can be. And if you're thinking of all these different ways that a sentence can be interpreted, then you should probably clarify it or change something. Make sure that you actually read the contracts. I know that when big companies attach terms and conditions, it's really easy to just click through it, but it's really, really important to read every contract, and that way you can know what obligations you may have, what obligations they have, and you can identify some of the terms that we'll talk about later. And on this last point, if the other side substantially performs, they don't do it perfectly, but they substantially perform, and you aren't happy with that, you shouldn't stop performance on your end, because then you may be in breach of the contract, not them. Terms and conditions. So I had mentioned this earlier. Typically, they're non-negotiable when you receive a package of terms and conditions from a company. You can try to change something if something doesn't work for you, but it's very, very difficult to get those changed and negotiated. And oftentimes terms and conditions will incorporate other policies, documents by reference. So that means they can include a link, and then it links to another document. All the terms in that document apply to the terms and conditions that you are currently reading. So it's important to go to that link and read those terms. All right, contract terms. So we will be talking about the different types of contract terms. It's really important that the contract describes each party's obligations, the payment terms, timeframes, ways to amend, ways to terminate, and then potentially dispute resolution and liability allocation provisions, risk allocation provisions. The number one question you should ask yourself is whether you can live with the contract. And that means is if you look at a term of a contract or the terms of a contract and you don't like it, but you could live with it, it may be the determinant for whether you accept those terms or not. Okay, so know what the contract is for. Don't assume anything, be as detailed as possible. So this gets a little bit into the ambiguity issue. Let's just take the first example. So company will provide client with food and beverage services, the evening catering services at the location and date the event set forth in an event order form in the form attached hereto as Exhibit A. So this language is very specific. It says that in order to provide the food and services, you need to set forth an event order in the form attached hereto as Exhibit A. So let's just say that this sentence had said, as set forth in an event order form, full stop. It's not clear what an event order form is. And so it's always good if you have some sort of form like that to attach it to the agreement. That way you can make sure that you're getting all the information that you need to perform the contract. Otherwise, you can have a little slip of paper that says, I'm ordering food and beverage services. You provide them, and then the other side says that's not good enough. So it's just good to have everything as clear as possible. Timing of the agreement or term, duration of the contract. Timeline depends on the parties. Oftentimes it's important to have an end date. So if you have an end date in mind, just write it down. Write down that date. Don't say, oh, it's in a year from now or something. It's just better if you have an end date to just say it. And oftentimes there may be terms in the contract that make it automatically renew. Be aware of those if you want a firm end date, because oftentimes automatic renewal provisions will require you or the parties to provide prior notice before the end of the term. So if you pass that end of the initial term date, then it's too late to provide that notice. You may have to resort to other termination modes of the contract. Pricing and payment terms. These are very important, obviously, and it's very important to have an affirmative obligation to actually pay the fees. So you might have a contract that says, that just lists the fees. And it says the fees will be X, but it doesn't require, it doesn't have a sentence like the one on this slide here that says that you will actually pay the fees for the services rendered. Having that affirmative obligation in there is really important. And you can have lots of other terms that dictate how you pay, when you pay, whether there's an issue. So just pay attention to the pricing and payment terms. Termination. There are lots of forms of and types of termination. Oftentimes, termination clauses will be there to make sure that you can give the other party or that you receive proper notice before the term end or the contract is terminated, because without that notice period, any party may terminate at any time unilaterally if you have a termination for convenience. And if you can terminate without any notice, that can be harmful because you may want to make adjustments for your business and take that into account. So it's good to have a little bit of a buffer so that you can make provisions for the terminating contract. There are, so in terms of the type of termination clauses, you can have termination for convenience, which I mentioned just now. That is when either party or a party can terminate for any reason or no reason at all. Oftentimes, that is the type of provision that it's really important to have a notice period. You can terminate for cause. So if a party breaches an agreement or violates law, you can terminate for that cause. Oftentimes, those types of provisions will have a cure period. So you can't just say you breached the contract, therefore I'm going to terminate for breach. You usually have to send a notice, and if the other party does not cure the breach within some given time period, then you can breach for, or you can terminate for a breach. Oh, actually, sorry, one more point. Another way that you could terminate, even if the contract doesn't say it doesn't provide any termination terms, you can go to the other party and try to mutually agree to terminate. All right. Contract remedies. So if you breach the contract, the main type of damages that are available are money damages. There are also equitable damages available. And equitable damages they come in various forms, but they basically are non-monetary in nature. So for example, if you want someone to actually perform or do an action, that could be one of the equitable remedies that you seek. Or if you want them to stop doing something, that's another equitable remedy. And make sure that, we'll talk about this later, but there are ways to limit the amount of damages in a contract. Another form of contract remedy to keep an eye out for are liquidated damages. And liquidated damages are basically an extra fee that you have to pay for an event occurring. So it could just be whatever the parties want. It could be like $200 if X occurs. Like if you terminate the contract or you breach the contract in any certain way. And so that's just another type of remedy to look out for. Liability limitations. So typically in contracts, there will be a clause that is in all capital letters, and it's disclaiming a party's liability under the contract. And it's really easy to skip over because it's all in caps, but definitely read it because it's very important. Typically, you can limit the types of claims that you're going to be liable for, or you could disclaim them. For example, in this event, this example, it talks about damages for breach of fiduciary duty. You can also have a cap on damages, so that just limits the amount of damages that you can incur under the contract. You can also carve stuff out of that. So you could say, except for breach of this term, liability is capped at $50, for example. And then you can limit the type of damages. So you can limit indirect, incidental damages, lost profits. Oftentimes parties will want to do this because these types of damages, indirect, incidental, special, all the ones listed in this last bullet here, can be really, they can grow out of proportion. So as an example of one of these types of damages, if you have an employee working and the employee falls and hits their head because of while doing their job, and it was your fault, then you might have to pay for the medical expenses. But what if that employee gets in their car and drives and gets into a car accident because they are feeling woozy or something? It's just the amount of damages can spiral out of control. So that's why parties oftentimes will limit or disclaim those types of damages. And when you're reading these limitation of liability provisions, it's important to keep in mind who it applies to. Sometimes if a company provides you with their form agreement, that form agreement might only cover them in these limitation of liability clauses. It won't cover you unless it says that you are covered under it. So make sure that you are also covered, or that both parties are covered under these types of provisions. Warranties are also very important. Oftentimes warranties will be in the form of product warranties, and it just is it's a assurance that a purchaser is getting what they're purchasing, for example. Indemnity. This is also another very important provision. It's a risk allocation provision. And it basically requires one party to pay for the losses incurred by the other party. And there is an example here that we can walk through of a very brief, very high level indemnity provision. They're usually much more detailed than this, but there are many issues within an indemnity provision. So I just kind of wanted to explain how it works and go through the issues. So this one says Company X shall indemnify and defend Company Y against all losses, damages, liabilities, penalties, fines, costs, or expenses of whatever kind, including reasonable attorney's fees that are incurred by indemnified party, collectively losses, arising out of any third-party claim alleging any grossly negligent act or omission of Company X or its personnel in connection with the performance of Company X's obligations under this agreement. Basically, it's saying Company X will pay Company Y for all losses arising out of any third-party claim that is related to an act or omission of company or its personnel under this agreement, basically. And so there are many levels to this. The first one is what constitutes the losses. What are you going to be paying for? And one type of loss that some people might not want to pay for is attorney's fees. So you can add the word reasonable in front, or you can try to remove it. And so that's just one question is, what are you paying for? The second one is, what claims are at issue? So what claims are going to be causing the damages that you end up paying for? And the question is it a third-party claim or is it just any claim? Oftentimes I'll see in contracts just the indemnification covering any claim, not third-party claims. And if it covers any claim, that means that the other side can bring a claim against you if you're company X, and then you would have to pay for the cost coming out of that that claim. So it's not a bad idea to limit this to third-party claims. And another question is, or another consideration is, to make sure that any acts that are bringing these damages about, like, what is the underlying cause? Why is the person bringing the claim? Anything that falls within that realm should be tied to the company X, and it should be tied to the agreement. Oftentimes I'll see provisions where the indemnification covers claims alleging any negligence of company X, period. And it doesn't limit it to performance under the agreement. So if company X goes off separate from the agreement and is negligent somehow, and then a claim gets brought against company Y, it wouldn't necessarily be covered under this, because it's not, that situation would be covered under this agreement, unless there's that last portion in there which says, in connection with the performance of company X's obligations under this agreement. So just make sure that it's tied to the agreement somehow is the takeaway from this. Okay, dispute resolution. Dispute resolution is basically a way to settle and resolve disputes outside of the court system. And that can come in many forms: mediation, arbitration. And connected to that is governing law and jurisdiction. So if there is a dispute, what law applies to the contract, and what courts will that be taken in? Oh, I see there's a question on limitation liability. For liability limitations, would I be liable if I receive a request for a job that looks normal and I send an independent contractor to that job, but the customer requester was actually dangerous and didn't really need our services? Should I add something in my contract just in case anything like that happens? Let me think about that. I think that's a little bit too specific. This I think the LCCR has clinics that help with very specific types of questions like that. I think that's a little bit outside of the scope. Sorry. Okay. In terms of governing law and jurisdiction, as a small business, it is important to try to get the courts listed here to be in your area. So if you're in Santa Clara, California, you don't want to be flying all the way to New York for a dispute because your contract says that the jurisdiction that you submitted to the jurisdiction of the courts located in New York. You want to try to have it as close to you as possible if you are able to negotiate that. And it's important to kind of link that to the law that's applied, because if you're litigating in California courts, it's important to also have California law to apply to that. oftentimes it makes things a lot simpler. And also pay attention to waivers of jury trial. All right, this slide covers another type of provision called force majeure. And it is, in general, a provision that says that a party won't be liable for any damages that result from a some sort of event that is out of their control. And sorry. This was very relevant with COVID-19, and there are a lot of nuances to this, but that's just something that you should generally be aware of. All right, so tips. Sorry. All right, to reiterate, it is very important to get your contracts in writing for the reasons I mentioned earlier. And both parties should sign it. That's important. The first paragraph of a contract will typically identify the parties, the effective date. It's important to list your company name to the T as it's shown on your corporate filings. So like down to the comma or the period. Before you even start contracting, it's important to understand the context. So make sure that you know what obligations are going to be covered, who will be responsible for them, what types of payments are going to be involved, the time frame, all of that stuff. You need to have a clear understanding of that before you start contracting and reviewing the contract even. All right, in terms of negotiation, you should always go back to this question: can you live with the contract as it stands? If you can't, then negotiate it. When you are negotiating, it is really important to know what is most important to you and anticipating what is important to the other side. All right. Keeping records. It's important to, once you enter into a contract, keep a record of all payments, or I mean, in general, you don't even have to enter into the contract. Just keep records of everything. But as it is relevant to contracts, it helps prove that you were performing under the contract. Negotiation tips. As alluded to earlier, it's important to know what you want. Do you want to just establish a relationship, or the possibilities are endless. Just know what is most important to you and what you want to get out of this, because when you're negotiating, you can get caught up in the little things and it's easy to lose sight of the big picture. But it's always important to just keep that in mind. It'll inform the whole negotiation. Also know their goals, or try to anticipate what they need. Do they want to get a good bargain, or do they need to fill an immediate need? Again, be clear about the contract terms. So if you're getting caught up in limitation of liability, indemnity, all that, just bring it back to the basics. Make sure that you understand the scope of the work. So what each party is going to be doing under the agreement. the price and the discounts, payment terms, term, and termination. So those are really, really crucial. Negotiate and agree. So make sure that you know what is most important to you, and then negotiate the other terms first. Save the big things that are important to you for last. That's just a negotiating tip. All right. So certain circumstances you may want to pause and just not dive in right away. And those are when the other party attempts to offer you anything outside of a written agreement. Make sure, again, everything is in writing. If the other party is rushing you, so you need a few days to review the contract, digest it, think about what you want. You should have that at minimum. If the other party is saying, get this to me within an hour, it's unreasonable and something might be wrong. The contract does not have a set fee amount or start and end date, termination. All of those crucial terms should be in the agreement. And one more point on the offers outside of the written agreement. If you have an agreement in place and then the parties want to agree to some sort of side arrangement or modification, make sure that that modification or side agreement is in a written document that potentially amends your current contract. Because that side arrangement may not be accounted for if a dispute comes about and a judge only has the written contract, the main contract agreement in front of them. It may be more difficult you face all the same issues with oral agreements when you have that oral side agreement. Okay, negotiations. When you are dealing with the government or public entities, like public agencies, it is important to know that they may require mandatory terms to flow down. So if you are going to hire a subcontractor to perform under the government contract, you may have to flow down those terms to the subcontractors. And it's important to know that you shouldn't modify those at all. They're meant to just pass through. All right, so in sum, it's important to keep good records and use written contracts that you understand and that you have read and reviewed and thought about. And when you are negotiating, keep your goals in mind, keep their goals in mind, and then again, understand the key contract terms. Make sure you read the contract. All right, and I think that is it. So yes, are there any questions? Okay, so I think that concludes it. Anna, do you have any final thoughts?
Thank you, Annalisa, for that information. Yeah, so I mean, I think there's probably folks that have some needs that are more specific to their business. I think you can go ahead and apply to our legal clinic. It's free one-on-one consultations with a volunteer attorney for 1 hour. We do have one this Thursday, and you can go ahead and apply. It's a very quick and easy registration. And my colleague Nicole will reach out to you to confirm your registration. But yeah, super appreciate it. Annalisa, I don't know if you have any additional thoughts or examples of like folks that you've helped with in terms of contracts, and maybe if there's anyone that or anyone in the any attendees that have any questions about like any contracts questions that might be helpful for them.
Mhm. Yeah, I mean, I'm open to any questions. And in terms of additional thoughts, I guess if you just had to take one takeaway is to actually read the contract and think about it, read it carefully. And if you don't know anything, if you see a word that you don't know, just try to Google it.
Yeah, and if you have a contract that you want someone to review, our attorneys also do that. So if you have any questions and like it's hard for you to like go through like lots of pages of a contract, or like, you know, some of the language is not as easy to understand, our attorneys can help review it for you, give you answer any questions that you may have. So it's actually a very useful resource for that. And then they can also draft up contracts for you and answer really any questions related to contracts. And does look like there was maybe one question. Yes, we do help with setting up a new contract. So if there is a template that folks have already that the attorney knows of, they will draft that up for you. If not, they can help you create a new contract. Thank you for your time, Annalisa. And thank you everyone else for your attendance. I will go ahead and send information about this presentation over to the registration email. There's also a link in the chat to register for the legal clinic. So you can go ahead and access that in the chat. Yeah, well, I'll leave it open for a couple minutes so that people can connect if they need to. But yeah, thank you so much. And we hope you have a good rest of your day.